King's understands the importance of a diverse workplace and is committed to providing employees, where reasonably practicable, an environment free from all forms of unlawful behaviour, including discrimination, harassment, bullying, and victimisation. As you are aware, King's has a diversity and workplace conduct policy that requires all employees to treat others with dignity, courtesy, and respect, and to not engage in conduct that may constitute unlawful behaviour. This policy is applicable to all King's Group employees, prospective employees, subcontractors, and persons who perform work of any nature for King's. King's considers unlawful behaviour to be unacceptable and it will not be tolerated under any circumstances. If proven, it may result in disciplinary action being taken against an employee. The Diversity and Workplace Conduct Policy includes a complaints procedure. We will talk about what to do if you are faced with a workplace conduct issue later in this module. What is discrimination? Direct discrimination is when a person or a group is treated less favourably than another person or a group in a similar situation because of a personal characteristic protected by law. So, as you can see, Jane, we are really happy with your progress. Congratulations! Now I want to talk to you about your development.
Thank you, Barry. I would be really keen to build my leadership skills.
Really?
Yes, really.
So you want to attend the Emerging Leaders Development Program? I know you were keen to settle and have a family with Bruce over the next few years.
But not right now.
Look, Jane, you must understand that training our people, although important, is quite a financial investment. I don't want to spend my rather limited training and development budget on someone who's going to leave after they finish the program. So for now, I've left you off the Emerging Leaders Program. Well, until you and Bruce are a little bit more sure about your future. I'm going to look at something a little more practical for you. You understand, don't you? Janice was a victim of sex discrimination, as she was treated less favourably than another person by her manager by not being included as part of the Emerging Leaders Development Program. This treatment was on the basis of her sex. Indirect discrimination is where an unreasonable requirement, condition, or practice is imposed that has or is likely to have the effect of disadvantaging people with a personal characteristic protected by law. For example, a manager requires his team to attend a regular team meeting at 7:30 a.m. when the normal start time for employees is 8:30 a.m. This may indirectly discriminate if an employee has caring responsibilities and is unable to attend at this time. It is unlawful to treat someone unfavourably because they have a characteristic protected by law. Treating a person less favourably can also include harassing or bullying a person. Federal discrimination laws include the Age Discrimination Act 2004, Australian Human Rights Commission Act 1986, the Disability Discrimination Act 1992, the Racial Discrimination Act 1975, and the Sex Discrimination Act 1984. There are many acts that constitute the federal discrimination law. There is also state and territory discrimination law. These generally overlap with the federal law and prohibit the same type of discrimination. Both federal and state territory laws apply, therefore employers and employees must comply with both. The laws do apply in slightly different ways, and there are some gaps in the protection that is offered between different states and territories and at a federal level. For New Zealand-based employees, the Human Rights Act 1993 applies and is very similar to Australian law, with a few minor differences in the protection that is offered. The personal characteristics protected by law include disability, disease or injury, parental status or status as a carer, race, colour, descent, national origin or ethnic background, age, gender, industrial activity, religion, pregnancy and breastfeeding, sexual orientation, marital status, political opinion, social origin, medical record, and an association with someone who has or is assumed to have one of these characteristics. A number of these characteristics are also covered by the Fair Work Act 2009. It is also against the law to treat someone unfavourably because you assume that they have a personal characteristic or may have it at some time in the future. Motive is irrelevant. In determining discrimination, a person does not have to be aware that they are discriminating, a person does not have to consider the treatment to be unfavourable, and the attribute does not have to be the only dominant reason for the treatment as long as it is a substantial reason. Sexual harassment is also prohibited under both Australian and New Zealand discrimination law. Sexual harassment is defined as unwelcome sexual behaviour which could be expected to make a person feel offended, humiliated or intimidated.
Well, hello sweetheart. Wow, you are looking smoking hot today. Nice outfit.
Bob, can we please talk about the composition of the project team for the new apparel client? I think we need a cross-divisional skills mix to ensure a holistic service approach.
Ah, yes, the new project team. Hey, do you have plans for the weekend? Maybe we could go grab a drink together and head to the beach. I bet you have a great bikini body.
Bob, can you please focus on the discussion? We are under an immense amount of time pressure with this project and we want to deliver what we have promised.
Janice, I love it when you get mad and flustered. You look so...
Bob, this discussion is over.
Oh, come on Janice, just having a bit of fun.
Janice was a victim of sexual harassment because Bob's behaviour towards her was sexual, unwelcome and offensive. Sexual harassment can be physical, verbal or written. It takes many forms, from relatively mild banter to actual physical violence. Some examples of sexual harassment include comments about a person's private life or the way they look, sexually suggestive behaviour such as leering or staring, brushing up against someone, touching, fondling or hugging, sexually suggestive comments or jokes, requests to go out or have sex, and sexually explicit emails, text messages, or posts on social networking sites. People may not always realise that their behaviour constitutes sexual harassment, but they must recognise that what is acceptable to one person may not be acceptable to another. Sexual harassment is not interaction, flirtation, or friendship, which is mutual or consensual. It does not have to be repeated. A single incident is enough to constitute a sexual harassment claim. It can also occur in the workplace, at work-related events, or between colleagues outside of work. It can be very blurry as to whether the behaviour that occurs outside work is connected to the employee's employment. Employees should therefore be cautious when socialising with colleagues outside of the workplace, and if choosing to do so, ensure that their behaviour is always professional and respectful. All incidents of harassment, no matter how large or small, or who is involved, require employers or managers to respond quickly and appropriately. If issues are left unaddressed, a hostile working environment can develop, which can expose employers to further complaints. While the person who sexually harasses or discriminates against someone else is liable for their behaviour, employers can also be held vicariously liable for acts of sexual harassment or discrimination by their employees. Employers can minimise their liability by demonstrating that they have taken all reasonable steps to prevent or avoid discrimination or harassment. Whether intended or not, bullying poses a significant risk to health and safety in the workplace. Workplace bullying is defined as a repeated, unreasonable behaviour directed towards an employee or a group of employees that creates risk to health and safety. The risk to health can be either physical or psychological.
I am sick of constantly cleaning up your mess. What kind of person allocates a standard courier job in front of a 90-minute-old priority client job? Do you even know how to do your job? What's wrong? Can't keep up with everyone else? I would be worried if I were you.
I was just trying to get every job covered. I don't know how I didn't pick up on the late job. I'm trying the best I can.
You really call this trying? Pathetic attempt. Are you going to have to explain to one of our top clients why this job was so late? No, I will. Maybe I should just tell them my fleet controller let me down. Again.
I'm so sorry. I'll try harder next time.
If there is a next time.
I really can't lose this job.
Bruce was subjected to bullying behaviour by Janice when she spoke to him in an aggressive and intimidating way and humiliated and belittled him in an open plan office environment. Under occupational health and safety legislation, employers have a duty to provide, so far as reasonably practicable, a working environment that is safe and without risks to the health and safety of employees. Employees have a duty to take reasonable care for their own health and safety and the health and safety of others in the workplace. Employees also have a duty to cooperate with the actions their employer takes to comply with OHS laws. Workplace bullying may constitute a breach of OHS law, and if proven, individuals and companies can be prosecuted. The Fair Work Commission also has jurisdiction to make stop bullying orders, which means that an employee may apply to the Fair Work Commission for an order to stop the bullying if they believe they are being bullied at work and it is creating a risk to their health and safety. Bullying can occur wherever people work together and in a range of different workplace relationships, including from managers to employees, between employees, and from employees to managers. Bullying can also include cyberbullying, which is bullying using technology. For example, using the internet, mobile phone, or other technology. Bullying can include aggressive or intimidating conduct, belittling or humiliating comments, spreading malicious rumours, teasing, practical jokes or initiation ceremonies, exclusion from work-related events, unreasonable work expectations, including too much or too little work, or work below or beyond a worker's skill level, and pressure to behave in an inappropriate manner. Serious instances of bullying, including threats to harm a person or damage to property, can be criminal matters and can be referred to the police. Victimization means subjecting a person to some form of detriment because they have taken action to address or resolve unlawful behaviour, for example, lodging a formal complaint. Victimization can include bullying and intimidation by co-workers, being denied a promotion or being moved to a position with lower responsibility, or being dismissed from employment. Victimization is also considered a breach of the diversity and workplace conduct policy and may result in formal disciplinary action. Now let's cover what sexual harassment, discrimination, bullying, and victimization are not. Sexual harassment is not behavior based on mutual attraction, friendship, and respect. Where interactions are welcome, it is not sexual harassment. Discrimination, bullying, and victimization should not be confused with legitimate comment, constructive feedback, and advice from superiors or colleagues in respect of work assignments or work performance. The Diversity in Workplace Conduct Policy outlines a set of responsibilities for employees. All King's employees are required to treat others with dignity, courtesy, and respect, not engage in unlawful behaviour, seek resolution where appropriate in accordance with the complaints procedure, refrain from making false, vexatious, or frivolous complaints, act with good faith in any initiatives taken to resolve concerns or complaints, and maintain confidentiality in respect of any complaint. Management responsibilities. The Diversity in Workplace Conduct Policy outlines a set of responsibilities for managers and supervisors. All King's managers and supervisors are required to model appropriate standards of behaviour, take steps to educate employees regarding their obligations, intervene promptly and appropriately when you become aware of inappropriate behaviour, act impartially when resolving issues and enforcing workplace behavioural standards, assist employees where appropriate in informal resolution of complaints, seek advice or refer formal complaints to the People, Culture and Safety team, and finally, ensure that employees who raise an issue are not victimised for doing so. The Diversity in Workplace Conduct Policy provides a complaints procedure. King's strongly encourages any employee who believes they have been discriminated against, bullied, harassed, or victimised to take appropriate action. There are different approaches to resolving a complaint, including informal resolution, assistance from the People, Culture and Safety team, mediation and conciliation, and finally, formal resolution. Informal resolution of workplace conduct concerns is encouraged in the first instance. The earlier that a person directly raises their concerns about the behaviour of another person, the more likely the behaviour will cease and that the working relationship between the employees will improve. Where possible, an employee should make a clear, polite, and discreet request for the person to cease the behaviour. This may be done informally in one of the following ways: individually approaching the employee face to face, approaching the employee with the support of their manager, asking their supervisor or manager to raise their concern with the employee on their behalf, composing an appropriate letter or email to the employee setting out their concern and requesting that they cease engaging in the behaviour, or a combination of any of these. Any employee or manager at any time may refer their concerns about inappropriate behaviour to the People, Culture and Safety team. When making a complaint, employees and managers are requested to provide as many specific details as possible. The People, Culture and Safety team will make a preliminary assessment of the complaint and consult with the relevant parties to assist them in determining the best resolution method. Where the parties are both willing to resolve the complaint and it is appropriate, mediation or conciliation may be organised. Mediation and conciliation is a confidential process where an independent and neutral third party assists the parties to negotiate and reach an agreement about how the complaint may be resolved. The mediator or conciliator will not impose a decision upon the parties. They may take suggestions for an agreement, give advice on likely agreement terms, and encourage the parties to reach an agreement. Where it is determined that conciliation or mediation is not appropriate or has been unsuccessful, a formal investigation may be necessary that could result in disciplinary action.